Hi, everybody. Harry here to talk about the oral arguments in the U.S. Supreme Court this morning over student loan forgiveness. It's going to get a little legal, but I think I can bring it home in sufficiently clear terms that everyone will be able to understand it. Okay, step back. COVID happens. And there is a pre-existing provision from September 11th, I believe, called the HEROES Act that basically permits in emergencies the Secretary of Education to modify or waive any regulation in the student loan program or to do new provisions that implicitly are somewhere in between. So, Betsy DeVos, remember her, Secretary of Education under Trump, first said when COVID came around, you don't have to pay student loans back for a time. And then the Biden administration perpetuated that policy. And then Biden took it a step further. Remember, he had actually campaigned on doing some student loan forgiveness, which is a huge problem in the country. Student loan debt is greater than credit card debt, entire credit card debt in this country. And for so many students just kind of starting out, it puts them into bankruptcy, basically takes them, off the grid for a lifetime. So a huge public policy problem. All right, but using the same regulatory authority, the HEROES Act and the emergency of COVID, the Biden administration gave a certain amount of relief, roughly $20,000 per each Pell recipient who totally was, current with their loans, etc. And it adds up to about $400 billion. All right, that's the program there, and the two cases challenging it in the Supreme Court this morning, one after the other. The first and by far most important, Biden versus Nebraska, and here's what happens there. 6 Republican attorneys general who really for political reasons just don't like the program, federal giveaways to elites and the like, brought suit. Now that's fine. That the real reason is political, but they have to show that they themselves, anybody has to show in federal court that there's a personal injury that they've sustained. And guess what? These 6 states really haven't, with one possible exception that I'll get to in a moment. Right? All these taxpayers get their loans forgiven. How does that hurt the states? It doesn't take away tax revenue. It doesn't really cost them a nickel. So there's really no injury there. But they don't like the program and they want to challenge it. So they've come up with a crafty argument to say we've been personally injured, which is something you need to have before you can come into court. You just can't come into federal court and say, I don't like this program or it injured somebody else, even though you wanted to. You need to show your own injury. And that's a requirement of the Constitution, and one that conservatives in particular have been very dogmatic about enforcing. Hey everyone, we're taking a quick break to ask you to take a second to like and subscribe. It's a quick thing that really helps the show. Thanks, and back to the video. So, they have to show their own injury, and really the only thing they try to do in court is the Attorney General of Missouri says Missouri has an injury, and the other 5 Republican AGs are trying to piggyback off that injury. And that injury is to an entity it's an entity in the state called MOHELA, which is the educational, it's the equivalent of the Department of Education in Missouri. But here's the rub. Maybe MOHELA has some injury in students not paying back some parts of the loan to MOHELA, but MOHELA declined to sue here. They're not in the case. In fact, they wouldn't even give, there's obviously a political standoff between Dems and Republicans. They wouldn't even give the Republican Attorney General documents. The Republican Attorney General had to file the equivalent of a FOIA even to get documents. So Mohila, which has the possible injury, is not suing, and the state very carefully has constructed Mohila, as it's entitled to do, so that Mohila cannot be sued. It can sue, but on its own authority. So, it's not in that sense an arm of the state. And it really is an independent, sub-entity within the state, which has a lot of advantages for the state, including if Mohila is liable for something that doesn't come from the state coffers. So the big point on standing is injury, the injury here, which every party must have from Mohila, good enough to ground an actual injury in fact, is the constitutional term, on the part of Missouri and the other 5 states. So that was a big part of the focus, which I'll come back to in a moment. Now on the merits. The Secretary of Education uses the HEROES Act, which says you can waive or modify any provision and also sort of do things in between, and that's the authority for $400 billion of relief. So first, the question is this a major question for the major questions doctrine? What is that? Who the heck really knows, because it's an invention of this court, a recent one, which basically says if it's a major question, then we're really going to think the Congress would have spoken to it expressly. The Congress would have said here, for example, the secretary can give debt relief, whereas it just said can waive or modify any provision. Now, what's the major questions doctrine? We don't know. It's just a thing that the new majority has put in to basically say, supposedly they're protecting the separation of powers, a watchword they love, by making sure that Congress isn't sort of snookered by the executive. They're always clipping the administrative wings of the executive. That's an ongoing theme with this Supreme Court, by having a general program and using it to do something really big. But does major mean costs a lot of money? Does major mean it's got real political ramifications? Does major mean it's a big change in the law? They're just working that out now. And, it's a doctrine that the progressives on the court view with distaste. Where the hell did it come from? Just seems like a way for the court to enhance its own power to strike down executive action. But there you have it. So, and it did seem as if especially Chief Justice and 4 or 5 of the big 5 were going to embrace that this is a major question, and on with that whole sort of agenda item for what is really a way to clip the wings of the executive branch. Okay, but another question on the merits, either for application of the major questions doctrine, or just even if you're doing it, which is, was Congress in fact clear enough? Okay, major question, Congress has to be clear, but maybe it was. Justice Kagan, who's an administrative law expert, had a line of questioning where she said, of course, how much clearer could you be? It's an emergency. You said waive or modify anything. They can't anticipate the particular emergency, but when it's an emergency, the secretary can do these things. And waive, modify might be kind of tinker around the edges, but waive, you can waive the entire loan. So why can't you, just reduce the loan? So she's going to argue, it looks like, as if it is, even if it's a major question, the requisite clarity from Congress is satisfied. But the feel of the argument is there were not going to be 5 votes for that position, and in particular, the 5 of the 6 anyway, including Roberts, were going to go down the road they've created themselves, and they love to pave, of the major questions doctrine. And that takes us back to standing. As I said, we'd return. Hang in there. We're nearly done on the law. So you could see the progressives, Jackson, Sotomayor, and Kagan really embracing the standing argument of the administration, saying the states don't have any kind of injury here, and the fact that this one agency in Missouri has maybe some doesn't count because they're not here. They've declined to sue, and we are very serious about the idea that you can't come into court to assert somebody else's injury. And there's part of the doctrine is that that's especially the case when you're suing the federal government. So come on, guys. This is what good conservatives have been saying for years. And only by expanding our standing doctrine could we let this suit proceed. And Justice Jackson had a pretty elegant line of questioning. She's been really good, I think, in coming up with a sort of show-stopping line of questions that she'll introduce maybe halfway through the argument and it'll make what about that? And what she's basically saying, we're worried about separation of powers in the major questions doctrine, or we're pretending to be. Well, but it's the same kind of consideration that underlies our standing doctrine. We don't want, especially here, to kind of loosen things up and let states essentially assert their independent entities' injury. That's something that the court's strict about policing. If you let them now, we're really loosening the whole strings of standing. We don't want to do that, right, guys? And it seemed pretty clear to me that was where the progressives are going to stake their claim and hope to get 5. And that would make the case just go away. If there's no injury to any of the parties before the court, there's no valid claim, and the case just gets dismissed because the court lacks jurisdiction to consider it. They have to have a party in front of them that is having a real injury. So I foresee the progressive position being no standing, and by the way, Congress was clear enough. And the conservatives, if there is standing, saying major questions, not enough, and striking it down. So the strategic hope of the progressives was to get a couple people on standing. Alito, who's written some of the opinions really emphasizing the separation of powers aspects and the need to be tight on standing, I think it's a lost cause here. He's ready to expand it to strike down this program. There's Alito for you. But there, Amy Coney Barrett seemed possibly interested in it. Maybe Kavanaugh. So that's how it'll be played out. I think the Vegas odds, as it were, would be in favor of the programs being struck down and a finding of standing. But to my mind, standing's really dubious here, and they would be distorting their standing doctrine to let that pass. Okay. There you have it. Biden v. Nebraska. Just a couple more points. First, the administration has said that COVID is going to cease to be a national emergency. I think it's May 19th. So that'll have ramifications for this program. But if they've already exercised this authority, then it's good to go. If the court strikes it down and it's no longer an emergency, going to be really tough to go forward. That's one. 2, there's a whole nother case here which came up, and the Supreme Court, the justices reached down to sort of consolidate it, and that's being argued now. And it's brought by 2 taxpayers, and they're saying they have standing because it's really kind of mean-spirited, but we didn't get relief because we don't have federal loans, and that's not fair. Now, that's dubious on standing. The fact that other people got a benefit that you didn't get, that's not normally what counts for standing. But at least one of the 2 is getting $10,000 in relief, and it could have been 20. So maybe they find standing. It matters less in that case because the actual claim, if they find standing, is basically, it doesn't involve the states. What's the beef of these 2 borrowers? They didn't give us a chance to weigh in. that the secretary went too quickly here, and we should have had a chance to be heard. He went under his emergency authority powers. It should have been a normal notice and comment so we could have been heard. In other words, a procedural failing, although the argument by the administration, the secretary, is that's what happens in an emergency. That's the kind of authority we've been given. So that's really a sideshow to what's the big case. And the big case, Biden v. Nebraska, A, will there be injury in fact based on this separate agency in Missouri? And B, will the major questions doctrine apply to strike down the Biden program, which will probably doom it, given that COVID won't be an emergency basis come pretty soon. That's what we need to be watching for. That's what the court will tell us, probably not until June. That's when I'll be back to explain it and talk about it. Along, by the way, once we're in June, lots of stuff's coming out this term, affirmative action cases being first and foremost. So, more to think about as we move into the second half of the Supreme Court term. I'll be back as important cases come up to try my best to explain them and give you my 2 cents. Until then, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.